Good afternoon, ladies and gentlemen. Thanks for joining us at the last session today. This panel discussion is in association with the Hangzhou Permanent Magnet Group, and we're very pleased to have a number of different speakers joining Jack Lifton, who will be chairing this discussion on the rare earth magnets and the changing US legal landscape. So listen and enjoy, and there'll be time for some Q&A just at the end. Thank you.
Today's topic is going to be one that should be near and dear to all of your hearts. The Hitachi patent situation for making rare magnet alloy powders. Correct? Okay. So I think that an attorney should start off. Yes?
Yeah. Okay.
Try to stay awake, because this is actually, to me, the most significant discussion of this entire meeting.
Hi, my name is Helen. So I'm just to give you a little bit background about the litigation history involving the neodymium iron boron magnets, okay? So if everyone look at the slides, you should think of the very first legal action. That's what? Brought by Crucible. So still anybody know this company? Crucible, right? Okay. Okay, good. That action was brought in 1995, but everyone only remembers two cases. That's the second one brought by Sumitomo and Mannequinch, because everyone knows that there is a cobalt patent that is a general exclusion order that stops everyone to sell products to the United States unless they have a license for Hitachi. And then the next action that was brought in 2012, and then I think most of the people also know that case, right? Okay. And I will talk about a little bit, but I'm not going to bore everyone about this. So back in 1995, Crucible brought a patent against someone, the largest Chinese magnet makers, even right now the largest Chinese magnet makers on one patent. Then if we look at this patent, I will defer to the experts on the panel discussion. So Dr. Omar and Dr. Bell, James, I mean, if you look at this patent, what do you think?
Yeah, I mean, this is a very simple claim. If you're going back to this very early time, you look at the date of the patent, 1986, very early on in neo-iron boron history. And this is the sort of thing I like in the way of a patent. It's very clear and very precise, and it's also very useful. And unfortunately, we seem to have lost an awful lot of that in a lot of the patents that are being talked about nowadays. So 30 to 36% of one rare earth, then with iron, and 6,000 to 35,000 ppm of oxygen. And the reason they claim that range is that you're actually making something better. You know, this was an improvement on the very wide range of oxygen contents that you would get in magnets at the time. And so, you know, go back and focus on that sort of thing. It's very simple, it's very precise, and it actually produces something that's better. And really, that's what a patent should be doing. Unfortunately, today, a lot of them aren't.
So in your opinion, I mean, maybe Dr. Omar can chime in, and even Jack, okay? So based on your opinion, each or whatever magnet being produced will be covered by this patent, right? Most likely.
Most likely.
Yeah,
I mean, the novel aspect of this claim is really the oxygen content. I think the composition range is within the original 651 Sumitomo Special Metals patent. So yes, and the nice thing is you can detect this in the finished product.
Yeah,
it's easy to analyze.
Yeah, but what happens? Someone continue to sell product to the United States. How? If these patents can cover any magnet made by any companies. So what someone did, I mean, actually there is a public information about that. That is someone adjusts the chemical composition for the rare earth. So it either adjusts below 30% or above 36%. And someone also adjusts the oxygen content to make the oxygen content outside the claim range. So that's a way you can design around or to make your product non-infringing. So it's not that simple, but it's that, okay? Oh, sorry. Okay, the next case, I think everyone knows that because Sumitomo and MagnetoDynamics brought a case in 1998, and then there's a general exclusion order that nobody can sell the products to the United States unless they have a license from Hitachi and MagnetoDynamics. And I believe everyone knows that at that time there are only 5 companies in China being licensed by Hitachi, right? And then we all know that the most important patent, the so-called containing the cobalt, expired in 2014 in July. But a few people knows what happened to this patent. That's the next one. Someone, okay, this case was filed in 1998. Someone, after 11 years, filed an ex parte re-examination. That's a terminology in the US legal system. That means to invalidate a patent before the United Patent and Trademark Office, okay, the USPTO, which granted the patent. So someone, a third party, anonymously went to the USPTO to challenge this patent in 2009. And what happened? A year later, the USPTO accepted and rejected all the claims in this patent. So that means this patent, the validity of this patent is gone. But this case is still under appeal by Hitachi Metals right now. So even though the USPTO have already rejected all the claims, but this proceeding is still going on. The point I want to point out is that if this person challenged this patent 11 years earlier, then this patent would have been gone. And then the market will open, right? To most the magnet maker, not just the Chinese companies. But the point is that people, if you don't know how to play or understand the legal system and then the patent rules in the United States, you can be stopped and being drafted. Being thrown out from the U.S. market. So that's the attorney, the job of me to navigate the clients through to make sure that they can get away from the patent barrier and at the same time get into the market. Okay. So the next slide, that's a very recent case in 2012. I think most of the people know that Hitachi Metals filed a litigation again against 3 Chinese companies and various downstream customers, which scare most of the downstream customers off because they need to pay a lot of attorney's fees to litigate the case. Our firm and I were very honored to be able to represent these 3 companies. And I believe Mr. Hu, the Ningbo Jinji representative, is here. And I hope that he's very satisfied with our representation of their case. At least everyone knows Ningbo Jinji currently was also authorized by Hitachi to sell magnets. So at least I want to say that Chinese companies, they are learning about the legal system in the United States. And then they know how to do, and then they are really willing to fight. Okay, this case, well, I have to contrast with the earlier case. In the earlier case, that's in this one, okay? I have to say, the Chinese company was sued, but they default. They refused to take any action in this case. That's why there was a general exclusion order. So if the Chinese company, they are brave enough to step forward behind their products, I believe, things can change. But always there is a misconception, okay? So I want to point out one thing. Samsung and Apple, they are having patent litigation, right? But nobody thinks that Samsung is ripping off Apple's technology, right? Nobody is thinking that. But if we change the story, if it's Apple suing a company for China, what will we think? You probably will think, oh, that Chinese company probably is ripping off Apple's technology, right? So it's a bias, it's a misconception. So I'm honored that the alliance, Joanna is going to introduce the alliance. They are thinking ahead and then playing ahead of the time. They hired our firm a year ago, and then they developed their own process to ensure that there will be no patent risk, in selling their products to the United States. So that's the whole background. I'm just trying to let you know about the legal system and then the patent barriers. So the alliance, they are getting away from the patent barriers, and now they are trying to get into the market where they respect the patents and then they have their own patents as well. Thank you.
Thank you, Karen.
Who's going to speak next?
Yeah.
Okay. And your topic?
Many people of you might have no idea what alliance is. Actually, back to 2 years ago, we have this further discussion the products and how to respect the intellectual property. So several companies decided to come together and we hold a meeting in northern China, and we decided that we have to formalize an alliance to protect ourselves, our own rights. Eventually, the quantity of the company being together reduced to 7, because 7 of this company include HPMG, Hangzhou Permanent. We have our own patent be filed in the in China and also in the different countries. So we decided to come together, and when we look at the Hitachi's license, we have spent our time to analyze more than 600 license so claimed by Hitachi, and we also spend a lot of time to try to go past and improve the current process what we are hiring. Among 7 of us, one company actually they provide majority of production, include the furnace, include stripe casting machine in China. So we are very experienced. 7 members of this group can contribute to the better technology to produce the neodymium iron boron. That's why 7 of us come together, and we understand that there's many concern about license in this country, in the US. So 7 companies, we decided everyone we have to pay something like 1.5 million, and we have a fund in large volume. Say something like 10 million. Say, okay, if there's any challenge, we are going to help a customer to overcome that, overcome any lawsuit. The reason why we do that is we try to respect intellectual property in this country as well as in the world. That's my point. That's also the purpose of Alliance.
You know, you cannot underestimate how important this is, because if you'll notice today there's a lot of discussion about innovation, and I saw a book recently about the great innovators, speaking of Jobs and Wozniak and people like that. This type of patent game stifles innovation. If iPad 6 is going to be the last one, it's going to be because of things, the last iteration. It'll be things like this. It's very important to understand that fairness is what's at issue here. Hitachi has had the field to themselves for a couple of decades. They've made a great deal of money. More power to them. People even older than I am can remember when Henry Ford fought the patent. There was a patent issued in 1890 for a vehicle run by a gasoline or kerosene burning engine, and everyone was paying on that until Henry Ford got fed up and made an alliance of car makers in Detroit in 1905, and they broke the patent. Now today we think it's ridiculous. How can anybody patent the idea of the automobile? But somebody did. Okay, in this sense, okay, I applaud Hitachi for getting this. I also attended law school, for getting this nonsense approved. I don't understand how it happened, but patent examiners are human, so they make mistakes. But I've seen this before, where large companies just keep getting patents. It's cheaper for them than doing any more research. What I'm telling you is that this type of action stifles the development of new technology. It kills it, because nobody's going to do. Who's going to do it? A little guy in a lab in Ningbo is not going to waste his time when he knows the giant's going to step on him. Okay, so it's very important for you end users to understand that what they're saying here is that you won't be subject to litigation if you look at them as a supplier, and I think that's the word you're trying to get out. This is a new game. As an American industrial type of person, I can tell you that if I were younger, I wouldn't sleep at night with young Chinese companies coming after the business, okay? So the best thing is to make love, not war. And Hitachi cannot maintain its position. Its day as the supreme leader is over. It has to be, or this whole industry is going to stop. Okay? So, does anybody? This is a rare opportunity to question the actual litigants. Okay? Anybody have any questions? Because the answers are here, not mine.
Yeah, before that, I think I probably want Dr. Ormerod and then Jessica to chime in a little bit, because two of them, they are actually the expert for one of the case, I mean the 855 case brought in 2012 and 2013. But because of some confidential information, we won't be able to tell too much about confidential things, but we can talk about some public information. Yeah. But I think Dr. Omar right now is also helping the Alliance, I mean, in challenging Hitachi Metals patent before the United States Patent and Trademark Office. And then I think he can share with you some public information about his observation about Hitachi Metals key patents.
Sure. I've been looking at three patents. I can't remember the numbers, so I'm going to have to look. The 385, which I think Helen had up here, the 765, both of those are essentially process patents. They talk about removal of very fine, ultra-fine neodymium or rare earth rich particles. So the process, I would argue it's almost impossible to detect that in the finished magnet. But that's not been my job. My job has been to look at the, search the prior art, analyze the prior art, and make a technical determination. Does the prior art anticipate or make obvious the claims, the key claims in those two patents? And in my opinion, there's a lot of prior art out there that does exactly that. The other patent I've been looking at is it's actually, it wasn't up there, it's the 5858123, and this is it's interesting that Helen put up the crucible patent, because this patent claims a carbon, oxygen, and nitrogen content range. And this is an English term, there are gobs of prior art for those specific claims. And again, my opinion is the prior art is either obvious or anticipates the claims in that patent as well. Okay.
Okay. How about you, James?
Yeah. I think I'd like to go back to this 651 patent. For the last 10 years or so now, we've been waiting for this patent to expire. You know, we'd be saying, oh God, we've got to wait till 2014 for this patent to expire. It's an awful long way away, you know, and it gets closer and it gets closer and it gets closer. And then just as it's about to go, Hitachi troll up another series of patents so that they can extend their royalty payments. Yeah? And they pick patents, like John's saying, those two on ultra-fine powders. Some of these patents are really horrible. They you know, going back to really good work that is done on discovering new things and filing patents to protect intellectual property is great. No problem with that at all. What I have a problem with is people inventing patents that are so complicated the patent examiner doesn't have time or effort to go through it in detail. The patent examiner who has done most of the permanent magnet patents here in the US had been, I don't think he works for them anymore, had been working for the patent office for about 30 years. In that time, he had been chief examiner for over 2,000 patents, which gives him an average of 3 working days per patent to examine a patent. Now, you can't do that. You know, you've got to be rubber stamping things to get them through in that sort of rate, and that's what's happening. There's all this trash coming through, and you take the ones that John was talking about, and one of the other people I talked to in connection with this case came up with a wonderful analogy for those patents. And it's a case of the compositions that Hitachi claim you use in these patents are compositions that no one would ever use because they're so high in rare earth that they make lousy magnets, okay? And basically what they're saying is, if you take some of the rare earth out, you get a better magnet. Well, Sagawa knew that in the first patent that he filed. You can see this beautiful diagram which shows the relationship between properties and the amount of rare earth. present. And he nailed it, you know, from day one as to where you want to be. And they've been moving towards that point progressively and getting better and better. This patent works somewhere over here, right? And it says that if you move in this direction, the properties get better, you know. I mean, it's ridiculous. And this other person I was talking to, he said that it's a bit like the Mrs. Fields cookie patent. Mrs. Fields chocolate chip cookies, if they had a patent, it would say that you put in 10% of chocolate chip cookies because they make wonderful chocolate chip cookies that way. So they file a patent. Someone comes along with a new patent and it says you put 20% of chocolate chip cookies in and then you take 10% of them out again. And that makes a wonderful cookie. Yeah? And they get a patent filed on that. Okay? So this is what's happening in the magnet business. People are finding one or two little ideas, putting them together, saying this hasn't been done before, and it produces a pretty good magnet. That's not the sort of patent that people should be paying royalties on. It's not the sort of patent that everyone who uses sintered neo in the US market should be supporting. And to be honest, I don't see what gives Hitachi the right to be the policeman over US magnet users and world magnet users, because it's product that comes into the US that matters. So, you know, I'm really disappointed that the 651 patent expiry wasn't the end of the situation. Like Jack said, they've had their time. They've had decades of work, of time to use the patents that they filed on legitimate stuff. And now it's time to move on. And there are a number of ways to move on. And one of them is to really highlight how fragile, how pointless, and how useless some of these patents out there actually are.
Actually, we also believe in this country, people who should have more choices to decide. Because unlike 10 years ago, nowadays magnetic application goes far and far in many applications, such like electric motors, you know, your mobile phone, electric products, and everywhere, and also e-mobile, e-car, so many things. And people, for those companies who produces, who has entrepreneur idea in their mind, should be able to use different company to work with, because so many engineer ability is not only within few companies, but they are among with the other companies also. So we like together and provide this market alternative choices.
Okay. Any questions out there? Yes, as usual.
Can we have a microphone? Sorry.
Okay. No.
Yeah, I can. Yeah, let me do that. Yeah,
Roaming
let me go.
Roaming microphone.
Sorry. Thank you.
Normally my voice carries.
Get one of those.
So you're looking at a patent requirement that it must be unique and not normally developed from other processes. Now, there are a number of cases in electric motors where patents have been granted that never should be. Quite frankly, in the American system, the only way you validate a patent is you have to challenge it and go through the courts. That's it.
That's
Good luck.
Because the system is broken.
Say again?
Because the system is broken. It isn't functioning.
It's never been fixed. It's been broken from the beginning.
Sure.
Yeah, that's true. So to challenge a patent, one way is like you say, you have to go to the proceeding, you go to a USPTO, or you go to the court to challenge the patent. But there is also another way that you can have your own unique manufacturing process or the products that do not implicate the patents. That's also another way to do.
Well, if you look at the average number of hours for a motor patent, it's about 12 hours to 14 hours review. In Germany, it's about 3 times that. In Japan, it's probably even more than that in terms of the way patent reviews are done. So Yes, our patent system is probably the worst.
Didn't we get that from Great Britain?
Yeah.
That's it? I believe so.
So that's what the Alliance is doing right now. So they have the Omar, the expert, right now challenging 3 of Hitachi Metals patents in the USPTO. People may ask, I mean, Hitachi is like hundreds or more than hundreds or maybe 600 patents worldwide. Then how about you cancel 3 and then what happened to the rest of the patents? But you have to think about the patents. Unless you use the patents, then you need to license or to not to use other people's patents. But if you don't use that patents, then why you are so concerned about that patent, right? So I think I can give you an example, and I think James Bell can talk about that as well. So there's one patent that's 874, which is not asserted against our clients in that case, but that's a patent regarding the niobium.
No, oh yeah, niobium, yes. Thank you for reminding me which one it was. Yeah, I mean, one of the 4 patents, again, used in the ITC, again, it was a really sloppy patent. I mean, it wasn't really anything novel. Huge amounts of prior art. It was to do with putting niobium into sintered neo-iron boron and producing better magnetic properties. Well, a lot of people had done that prior to this particular patent. I think how this patent probably got through is because they had looked at all the prior art. They said, oh, well, this one covers this area here. This one covers this area here. Ooh, someone missed a bit in the middle. So we'll cover that for a start. And the reason it was so sloppy is because they put into the compositional equation neodymium, iron, boron, you know, carbon maybe if you want to use it, cobalt if you want to use it, a few other substitutes that you can put in. But that was all. And they never used the terminology of using extra elements in the composition. I mean, normally you would say consisting of, containing, you know, well, containing is good because then you can include all sorts of other things. But they defined this chemical formula as containing those elements and no others, right? So that immediately rules out any magnet that has an addition of aluminum, silicon, gallium, you know, I mean, all sorts of things that are regularly put in. So the magnet just, the patent just doesn't apply. So it was badly written up. It wasn't tested properly. It ended up as a patent that says, if you've got niobium in there, you're contravening our patent. And of course, Hitachi could analyze chemically and say, you know, that's one of the few they could actually analyze and say, you know, it overlaps our patent range. But technically, none of the examples that they tested did overlap the patent range because they had all sorts of other things in that they'd never even put into the patent. So bad, just really, really bad patent.
Yeah, without attacking the patent, I have one question. So is it physically, economically possible to produce a magnet without adding any niobium?
Yes,
it's possible.
Absolutely.
It's absolutely, right? So if you look at your product and then if your magnet does not contain any niobium, you don't have to worry this patent. My point is that there are so many patents out there, but if you can be convinced by the alliance or the attorneys, I mean, that the magnets you are buying will not be infringing or implicating any other's patents, I think there is no way that the patentee will be able to sue you because there is just no proof of infringement. So I think that's the key I hope that to share with you today. And I also agree with Joanne that, I mean, the alliance will give you more options, I mean, more alternative of the products. I know patents, I mean, it's good, protect the innovation. At the same time, it's being used as a business, I mean, to gain the market shares. I mean, it's good. I mean, I think patent is good. So what I want to say is that we should let the company to manufacture good product, quality product, affordable products, and let all the legal issues like the patent things to the attorneys to handle, okay? So we should not mix these two things together. And then the products, I mean, you choose, they end up being very limited.
I have a question for the panel.
Okay.
I recently saw a patent for reforming magnets, rare earth permanent magnets. And in this system, no wet chemistry is used, like that. Take scrap rare earth permanent magnets, neodymium iron boron, and they are reformed into new magnets with customer specifications. Now, this is a patent that's pending in the United States and has been issued, I think, in China. I'm not sure. And it's a company called Urban Mining.
Yes.
Now, normally I ignore all companies with scientists with wild hair, okay? And this is a perfect example. When this gentleman approached me in Ningbo, I thought of calling for the police because he's out of a film, a Frankenstein film, okay? And my partner, Dr. Gareth Hatch, who has his PhD from Birmingham in magnetics, said to me, no, I know this guy. We went to school together. He said, I'll go have a drink with him. I said, okay, go away. So they went away, and Gareth came back and said, you know, this guy's for real. He's serious. And he's already produced several tons of material at Beijing Institute of Technology where he's a visiting professor. Here's my question. I take a garbage bag from your company with scrap. I make it into new magnets. They meet a specification. Am I violating your patent?
Yes, even if you recycle everything, but when you...
But I'm not making your magnet. I'm making mine.
No, the question is, well, when you remake the magnet, are you utilizing or using the patents I have? If no, then you are fine. So the very simple question is whether you use the patent of others. That's the key, whether it's recycle, remake, or whatever. Oh,
I'm actually wondering, are either of you involved in this litigation? No, I mean with Urban Mining.
Huh?
Urban Mining.
I don't know. I think there's currently no litigation involving
Yes, they've
Urban Mining.
retained as counsel those who originally brought the Hitachi suit here.
Okay.
And
Could it be?
yeah.
It's not Alston.
Okay. The point is that this is a whole new game now, and what I'm saying is Hitachi could stifle recycling by attaching it. And so I think this is going to be litigated, and I think it's going to come out that those who recycle scrap are not violating any patents. That's my opinion. I'm just wondering. Yeah.
Can I make a comment? I think there's two ways you can look at that. First of all, if you are reprocessing material within a factory, so you've got scrap within a factory that hasn't been sold before, then recycling it using this process and making good magnets out of it again and then selling them, I think technically you would have to pay licenses on.
Right.
If you're taking end-of-life product out of like disk drives or something and then hydrogen decrepitating it and turning it into powder and making sintered magnets again, it gets very interesting because it's likely that those magnets that you're reprocessing have already had a royalty paid on them.
Right.
And I know there was a lot of discussion years back when Sumitomo at the time were licensing alloy producers and not just magnet makers. And there was a lot of discussion, I don't remember how it came out, but it was like you can't license things twice. If you license a company and the company who's making the alloy is paying royalties to Sumitomo, then you can't also take royalties from the people who are making the magnets. And I know you get into arguments about what the patents actually cover and this sort of thing, but I think it's debatable. You know, if you were using end-of-life product and reprocessing it, and royalties had already been paid, I'd be inclined to argue that no, you don't need to do that.
Okay.
Well, okay, I kind of agree and disagree to a certain point. I mean, that's how lawyer talks, right? So that goes into a legal principle about the gray area between remanufacture and then a repair. So if you repair something, that's true. I mean, it's already licensed, you can repair something, but it becomes remanufactured and it becomes a new product, then you probably are still performing the steps that's claimed in the patent. Then in that situation,
But
the license becomes...
this would be a significantly different process.
Oh, if the process is different, I think
yes,
it should be fine,
it is. It's not standard.
If it does not go to mystery casting, HD, and then...
And particularly if you use that material as a powder to go into, say, a bonded magnet operation rather than sintered magnet. Again, it's even clearer. In fact, I'd like to have a look at that patent application because it hasn't actually been published yet, has it?
No.
Right.
No, but it's intriguing because this is not just a desktop. They've made several tons of magnets. And the company tells me they don't think they're violating any patents for the reasons that have been discussed in the panel. One thing is how many times can you pay, and they buy scrap from all kinds of sources, and they process it. They don't even know the origin, okay? So it's unlikely, I agree with you if you're doing it in the same factory, that's an issue. Maybe you just count it, but you only count it once.
Yes, yeah.
Wow, that's a real, that's for learned judges to debate.
So each of you has a booklet, introducing the alliance, and then within the booklet there's a questionnaire. So if you have time, and then please fill out the questionnaire and return to our people over here, so that will help my job and help the alliance job.
We will highly appreciate it.
Yeah, thank you, yeah.
Am I supposed to say something?
Yeah.
Where does this video go? Where's it?
Well, that probably violates the copyright. You need the consent of the people sitting here.
Because just to review this discussion, this is very interesting to me because, quite frankly, the future of the industry depends on this discussion. So to know, I don't know what's going to happen in the courts, but I suspect with these patents expiring, that even the patent court in Washington will be able to see, games being played like, well, wait a minute, we're going to add 3% banana oil to it, that kind of thing. So I suspect that this regime is over.
Yes, this gentleman.
This is very interesting and fascinating, but it's probably the tip of the iceberg. You are talking about a few patents here that are very important from a legal and business point of view. But as an inventor and a researcher, my experience is that most patents that I've seen are just written and never really, you could say almost useless in terms of. So how many, can you give an idea of how many patents are, really, is that 10% of patents that are really useful or because when you say that the examiner spends only 3 days, well, put yourself in his shoes or her shoes. Most of what he says, okay, next, doesn't matter too much. So how many patents are really important and useful?
Good question.
Yeah, that's a really a good question. I think I only have some statistics, to use to answer you. So if we take, yearly the patents being granted by the USPTO, I think it's, a few millions of patents being granted each year. But each year, the patent litigation only is about 2,000 to 3,000 patent cases. And then let's say if each case has 2 patents, so you have 6,000 cases, 6,000 patents be litigated each year. But you have millions of patent granted, so it's just a fraction of granted patents that can be considered important. And then if we take another example about the Samsung and Apple's litigation, both companies must have thousands of patents, right? But in their litigation in the United States, I think they probably choose and pick about at most 20 patents, in the fight. So out of 1,000 patent portfolio, they only pick maybe 20 or 30 patents. So that probably tells you maybe the importance of the patent. But at the same time, also it can relate to the cost of litigation. So if you want to litigate all the patents, it can be very expensive. But sometimes the patents are really not rise to the value that you really want to assert the patent. So that's why when Hitachi brought the case in 2012 from its entire portfolio, I would assume Hitachi must have chosen carefully the most important patents to litigate against all the companies. So that's how it works. So you can have a lot.
And I think that goes to answering your question, how many of them are really useful? Well, out of all the hundreds of patents that Hitachi had to choose from, they chose 4, which, from my point of view, are pretty poor. And if those are the best 4 they have, that would suggest that the others are even less useful.
Even worse than these 4 patents. But basically 600 patents, they're very useful to block the other person to get into this market.
Yes. Quantity, not quality.
Quantity-wise.
Yes.
But patents are important. I want to say I still encourage people to file patents, okay?
No? You know, I can sort of give you an answer. Just to tell you how this game is played, because Hitachi did not invent it. In the 1980s, Corning Glass patented the substrate, the honeycomb substrate for the automotive catalytic converter. By the time I got to the situation, they had had 5,600 patents issued. And it was the most ever issued for any device in the history of the U.S. Patent Office. So no matter what anybody did anywhere in the world, they said, that's covered by number 2,917. To this day, Corning is the dominant force in that so-called industry. They have one licensee, a Japanese company, NGK, ceramic company. And what concerns me here is that this mustn't happen to the magnet industry. But glass is something, glass has a huge capital requirement. You don't go into glass making with a few dollars. Magnet making is not such a difficult, it's a difficult field, but its capital cost is much, much less. And so the problem is no one should be inhibited from going into the magnet business by this kind of nonsense. And you have to be careful because Hitachi's a big, I think the Hitachi unit, Hitachi Metals, is $8 billion in sales, which I'm sure is more than all the magnet companies that are in, at least here, okay, out non-China. So they've pretty much had it their way, and I suspect they have hundreds of patents in this area. And they have spent tens of millions of, maybe $100 million on getting, they're not going to go easily, but some of these things are ridiculous. And I think once you pierce this screen, it's going to go. It's going to go. So it's not about how many patents they have is in fact a negative, because you can see right through the game right away. How much, wouldn't they be better off researching a cure for cancer than whether or not niobium, a detectable niobium, it changes the coercivity of a magnet? I mean, come on. So I just think that this is the beginning of the end for them, and that smaller companies are going to benefit very, very much by this. Your problem is going to be convincing the end users that they're not in danger of one of their own, a Global 1000 company, coming after them, which they don't want. They don't want to be involved in. So this has to come to a head, and I guess it's going to happen now. Yeah. Okay. 2014 was always the magic number in the rare earth industry for the reason that he said. Everybody said, when the patent expires, everybody will be in the magnet business. I don't think so.
Yeah. So I think I still have one last story to share. So patents, I still want to say that patents are important. I'm not saying that patents are not important. At least you have patents, you can stop other people from doing the same thing, I mean, as patents by your invention. I just give you one quick example. So if we took our iPhone, if people have iPhone, I mean, how iPhone unlock slide, right? Apple has several patents on that feature. And then if you have, I mean, phones like Samsung, HTC, or Huawei, or other phone, how those phones unlock? They're probably going up, or like something else, but definitely not sliding. So with the patent, you can stop other people from doing the same sliding feature claiming the patent, but you cannot stop people from doing other ways to unlock the phone. So the patent, you can block others, but at the same time, other competitors, they can find ways to work around or to develop new ways that do not implicate the patents, okay?
We can't, because Apple filed that one, slide one. We can't, you know, we can go the other route to make sure that you won't have any problem with Apple patent to go through the door like this. That's why we 7 company we're trying to do to help the, you know, the industry here in the States.
Okay.
Yes, please.
Okay. Oh, hold on. Is it?
Let's take this one question.
Okay.
Yeah.
Okay.
Wrap it up.
Can you estimate about when all this will be settled, or you have stuff ongoing? You have lawsuits ongoing. Can you estimate when that will be closed, or?
I mean, which one? Estimate what? Sorry.
I mean, you're trying to have certain patents dismissed.
Yes.
Do you know when that will be final? Or?
We filed those
August,
IPR
end of August.
in August, yeah. So the initial result will be one patent will by the end of this year, and the other two other initial result will be sometime March next year. Yeah. So I mean that's another good example. I mean for that COBOL patent, somebody wait for 11 years to challenge the patents, but now the alliance they are together already taking the actions to challenge the patents. Yeah. So they are not waiting for another 11 years, and then you should not be waiting for 11 years as well.
It's faster growing industry, and everyone try to position themselves in a better position in the market. And I would like to ask you gentlemen, don't wait and take reaction now.